All right, folks, it's a few minutes after 12, so I think we're going to get started and people can trickle in as they come. Just wanted to check in. Did any folks have trouble connecting to the webinar today? Any issues with that? Feel free to add your comments in the chat as you are unfortunately muted for the duration. No problems? Awesome. Great. Okay, so I will dive right in. My name is Kate Fain, and I work for the College of Midwives of Ontario in Communications and Stakeholder Relations. It's my pleasure to welcome you to this mandatory reporting webinar today. To get started, I'd like to acknowledge the grounds on which we are privileged to gather here today. Where I'm sitting, it is gray, somewhat drizzly, and it reminds me very much of where I grew up, which is the unceded territory of the Musqueam people in what is now British Columbia. I've been thinking a lot about that particular land over the past 3 months, as it's been pretty dramatically harmed by climate change. And even as we speak, land defenders in Wet'suwet'en are seeking to protect the health of the land and being faced with militarized raids from the RCMP on their own sovereign territory. So something that I'm spending a lot of time thinking about right now. But the land on which I currently live, as well as the land on which the College of Midwives of Ontario is located, is the traditional territory of the Wendat, the Haudenosaunee, the Anishinaabeg, and the Mississaugas of the Credit. But today, Indigenous, Inuit, and Métis people from many nations call it home. The college is mindful of the ways in which colonization have sought to eradicate the practice of Indigenous midwifery, but also how Indigenous midwives are leading its revival and returning births to communities. So we commit to actively collaborating with our partners to identify, remove, and prevent barriers for Indigenous midwives or clients in our work, and we invite all feedback in this regard. So just some housekeeping notes for today. This webinar is being recorded and will be shared publicly for educational purposes. We invite you to introduce yourselves in the chat if you would like, perhaps your name and your location, the practice you're with. If you have any questions for us to address at the end of the session, please add them in the Q&A tab. We'll answer them at the end, and any questions that we don't have time to get to, we can gladly provide you with a personalized response after the webinar. So we've got 3 fabulous presenters today. They are Michelle Pierre-Gastini, who is our Manager of Professional Conduct, Ashley Coyne, who is our Professional Conduct Coordinator, and from the Association of Ontario Midwives, Deborah Bonser. So with that, I would like to pass it over to Michelle.
Thank you, Kate, and welcome everyone. We're going to start the webinar today with an introduction to mandatory reporting, what mandatory reporting is, and the purpose of mandatory reporting. I will then explain what happens at the college when we receive a report and provide some statistics. Then we'll get into the circumstances or situations where midwives are required to make a mandatory report to the college. Deborah, do you want to explain where we will go from there?
Yeah, it's quite exciting too. I would add that, the AOM would like to thank the CMO for offering us a seat here and really working with us collaboratively. So we do also want to highlight the support that's available for determining if a situation requires a mandatory report. And resources are available from the CMO and, of course, assistance from the AOM on-call. And we want to talk about support for early interventions for safety that may help to prevent a situation from escalating to one where a report is required. And then, of course, leave time for the question and answer period.
So before we start, we are both very happy to be providing this joint webinar to you. We both deal with the mandatory reporting in our respective roles. But as all of you know, the college and the association have different mandates. So before moving forward, we just like to highlight our different mandates. The College of Midwives' purpose is to regulate the profession of midwifery in the public interest for the protection of the public.
And the AOM represents and supports midwives with the ultimate goal of, creating a safe environment for midwives to work in and safe care for clients.
Okay, hi everyone. I'm Ashley. I'm the Professional Conduct Coordinator at the college. I'm going to just cover the two main questions that you might be asking yourself joining this webinar today, which is obviously what is a mandatory report. So a mandatory report is a report that is required by law. Midwives, employers and practice owners have legal obligations to make certain reports about other regulated healthcare professionals, including other midwives. Midwives also have obligations to make certain reports about themselves. The reporting obligations of midwives are set out in the Regulated Health Professions Act, which we call the RHBA, and the College Registration Regulation and College Bylaws. Midwives may also choose to report or provide information to the college in situations where there is no legal obligation to do so, and we call this permissive reporting. So this brings me to my next question. Why is mandatory reporting important? So obviously mandatory reporting is important. Well, the short answer is public protection. Receiving information about instances of professional misconduct, incompetence, professional negligence, sexual abuse, or concerns regarding incapacity affecting client care alerts the college to situations where midwives may not be practicing safely, and it allows the college to take appropriate steps to assess and address risks to public safety where required. Permissive reporting also achieves the same goals as mandatory reporting, and most importantly, without receiving this information, the college is handicapped in its ability to regulate in the public interest. The college looks into every mandatory and permissive report it receives to determine if regulatory response is required. Not every report results in a regulatory response, and Michelle is going to be able to explain a little bit more about this.
Thanks, Ashley. So first of all, I'm aware that mandatory reporting can incite fear and some apprehension amongst both the reporters and the subject of a mandatory report. It's important, I think, to understand that the reporting obligations are requirements and not optional. Essentially, the midwife or the employer has no choice but to report in certain circumstances. Making a mandatory report about yourself or being a subject of a mandatory report doesn't suggest that you're in trouble with the college. It doesn't affect the status of your membership or your ability to practice. If you are a subject of a mandatory or a permissive report, the report itself simply triggers a process at the college where we consider the information and the registrar decides if regulatory action, if any, is required to protect the public. We're talking about mandatory reports today, but it's important to note that this process that I'm going to explain is the same for any information that comes to the college's attention in any way other than a formal complaint. The complaints process is separate, and we would need another webinar to talk about the complaints process. So when the college receives a report, it will first confirm receipt to the reporter. Because a mandatory report is not a formal complaint, the reporter is simply providing information to the college and is not a party to the process. The reporter is not involved in the process unless, of course, the midwife is making a report about herself, and it is assumed that the report is made in good faith. The registrar has a responsibility and an obligation to take steps to consider the alleged conduct or the actions of the midwife. The college will review the report and determine if further inquiries are needed to assist the registrar in determining the risk to the public. We call this step completing preliminary inquiries, and the inquiries that we conduct will vary on the information we receive. Sometimes no further information is required. Other times, the college will contact the reporter for further information. We may request to obtain the relevant midwifery record, or we may ask the midwife who is the subject of the report to provide some information. So I think we're just going to move to the next slide. The process is designed to be fair. Once the college has the information it needs, or the information that it's able to get through making preliminary inquiries about a midwife's conduct that raises concerns about misconduct capacity, the college completes a risk assessment. It'll first assess the seriousness of or the risks associated with the reported conduct or behavior. So you'll note from this slide that the allegations are assessed based on risk to the public and taken at face value. The college will then determine if there is information to suggest that the midwife failed to maintain a standard. The majority of the reports that we receive are about clinical concerns and a failure to meet a clinical standard. So the series of questions on the slide are all considered when deciding on an outcome. The college will consider the risk to the public in conjunction with any aggravating and mitigating factors, which can include actions taken by the employer, the hospital, or the practice regarding the matter, whether there's a formal complaint, prior history of the midwife, actions taken by the midwife to improve their practice, just to mention a few, and any additional information that the registrar believes relevant regarding the matter. The decision tree that we currently use, and you're getting a sneak peek of it now because we are planning on making it public, but we're just going through the final design stages of it. But this is the formula that the college uses when it makes decisions on matters. So you'll notice that the dispositions on the bottom of the slide are the actions that the registrar may take. They range from taking no action to commencing an investigation. If the registrar determines that there is little or no risk to the public, she'll likely take no action on the report or send a reminder to the midwife. Conversely, if the registrar believes that the midwife committed an act of professional misconduct or is incompetent and the conduct poses a medium or high risk to the public, she may choose to commence an investigation into the concern. In order to commence an investigation, she must have reasonable and probable grounds to do so. Reasonable and probable grounds means that there's just more than a mere suspicion that the conduct may have occurred. Sometimes, rather than commencing an investigation, the registrar will write an educative letter to the midwife. This usually happens when the level of risk is medium, but the registrar either doesn't have enough reasonable and probable grounds to commence an investigation, or there are strong mitigating factors that lessen the risk to the public. So although our decision-making process is consistent, each case has individual factors in determining appropriate outcome. The process for information the college receives about incapacity is different. The registrar will make inquiries she considers appropriate. The college really doesn't receive many reports about incapacity, but often the registrar's inquiries will consist of a letter to the member asking for a submission on how she is managing her condition. This will assist the registrar in determining whether she has concerns that a midwife is incapacitated and if a health inquiry should be commenced. Just want to mention that historically, this college has, over 2 years, we have not commenced a health inquiry, and I don't think that this college has ever referred a matter to the Fitness to Practice Committee. The midwife who made the report about themselves, or the midwife who was the subject of the report, will receive a letter advising the outcome or next step. We recognize that it can be stressful for reporters and midwives who are subjects of reports. If you're making a report about yourself, provide the required information in your report. Having the information the college requires will assist us and may avoid the college contacting you to obtain more information about your report, and can simply inform you of the outcome of the preliminary inquiries. The same goes for reports about others. Providing the relevant information and the required information in your report will assist the college in its assessment. When making a report about others, I recommend telling the midwife that because of these certain circumstances, they are obliged to make a mandatory report to the college. It may be helpful to provide the midwife with the college's or the association's contact information so that the midwife can obtain information about next steps on her own. So let's put mandatory reporting into perspective with some statistics. I've compiled the numbers of mandatory reports we received in total for the last year and a half. The college does report on these numbers annually in its annual reports. Basically, in the last year and a half, the college has received and processed 100 reports. This includes reports about oneself, reports received from others. Of the 100 reports, Only 6 resulted in a registrar's investigation. So this means that 94 resulted in no formal regulatory action being taken. In 33 cases, the college wrote to the midwife in an educative manner to remind the midwife of certain standards or educate them on an expectation or requirement. More often than not, and 61 times in the last year and a half, we've closed the file without taking any further action. So you might be wondering what the outcome is of an investigation. So here are some stats from that same period. I guess first, for those of you that are not aware, the Icrc, the Inquiries, Complaints, and Reports Committee, is the committee that investigates and renders decisions on complaints and considers and makes decisions on reports. The committee is comprised of midwives and public members appointed by council. Staff are not involved in the decision-making. In the last year and a half, the Icrc issued 84 decisions in total. It was a very busy year, but 13 of those decisions related to investigation matters. I haven't provided the stats on the outcomes of complaints matters, but I can advise you that only 1 complaint matter was referred to discipline in the last year and a half. If you're interested about disposition of complaints matters, you can always find that information in our annual reports and our quarterly reports that are posted to our website. So no decisions on investigation matters resulted in a referral to discipline. The outcomes were all remedial in nature. Sometimes the Icrc may decide to issue more than 1 outcome for 1 investigation. So in 5 cases, the Icrc decided to take no action. In 4 cases, the Icrc felt that advice and recommendations would suffice in addressing the Icrc's concerns. In 5 cases, the Icrc ordered remediation. We call remediation that's ordered by the Icrc SCRPs. And in 2 cases, the Icrc ordered a combination of an oral caution and remediation. This outcome is reflective of a serious concern where the Icrc is of the belief that the midwife's conduct must improve and is usually a disposition short of a referral to discipline. An oral caution is a strong message intended to improve the midwife's practice. All of these outcomes are considered remedial. So the purpose of sharing this information here is to inform midwives that just because the college receives a mandatory report, it doesn't mean that the college will start an investigation. And even if it does, it is because the registrar believes there is a risk to public safety. After going through the investigation, the statistics demonstrate that the outcomes are usually remedial and meant to assist the midwife in her future practice. When a matter is referred to discipline, similarly, the college's focus is remedial wherever possible. Midwives should remember that only a discipline committee can make findings of professional misconduct or incompetence, and only a fitness to practice committee can make findings of incapacity. If a report results in a college investigation, the Icrc screens matters to assess whether the conduct rises to the level of professional misconduct, incompetence, or incapacity, and determines what outcome is appropriate to address any concerning conduct. So let's move to the next slide. I don't think that you can have a webinar on mandatory reporting and not talk about the reporting of sexual abuse. I note that this college does not deal with this issue frequently. The college has a great guideline that provides great information on this reporting requirement, and we're not going to go into details in this webinar. This is simply a high-level overview. A midwife should be filing a report if they have reasonable grounds to believe a regulated healthcare professional of any college, including midwives, has sexually abused a client. The midwife must have obtained this information in the course of practicing the profession. If your client discloses to you that they have been sexually abused, that's sufficient reasonable grounds for purposes of reporting in this category. Sexual abuse does not include touching behavior or remarks of a clinical nature appropriate to the service provided. The RHPA defines sexual abuse broadly to include sexual intercourse or other forms of physical sexual relations between a midwife and their client, touching of a sexual nature of the client by the midwife, behavior or remarks of a sexual nature by the midwife to their client. So I'm ready to turn it over to Deborah and take a break and a glass of water. Deborah, would you like to poll the audience?
Yeah, so we're going to do a little audience poll, and this is the first question. So midwife A, sorry, can you put that, can you put it down for a sec, Kate? Because I'm still reading the question.
Sorry about that.
I'll improvise. Midwife A is doing a clinically indicated vaginal exam of a client, and midwife B is concerned that midwife A did not obtain the client's consent before conducting the exam. So the question is, should midwife B make a mandatory report to the college about sexual abuse of that client? So sorry, Kate, do you want to put the poll up?
No, it was me who jumped the gun.
We'll just give people a few seconds to answer whether you think that the midwife should report this as sexual abuse. And then we'll have Michelle start to debrief the response.
So we're at about 60% of participants voting. This is great. I think when we hit 75 or 80, I'll call it and get those answers in.
Knowing that some midwives are multitasking while they're doing this, so they can't stop to answer the poll.
Well, we have hit 71, so I think that's probably acceptable.
I think that's great. All right, so Michelle, do you want to start with the debrief?
Wonderful. I think that the results show what the majority show, the answer that I would probably give. This scenario does not suggest sexual abuse, and therefore the midwife would not have to report this as sexual abuse. It appears to be more of a concern about obtaining informed consent. It does involve a client, and the information was obtained in the course of practicing the profession, but the midwife was not of the belief that the touching was of a sexual nature, nor did the client raise concerns about touching of a sexual nature.
Yeah, it's complicated because as midwives, we often in our exams and in our care, we're, dealing with parts of the body that are sexualized. So it's easy to become confused about this one. And, the midwife A could consider whether or not, this is a professional misconduct, which if it is an exam without consent, it's a professional misconduct. But reporting it to the CMO may not be your first step. You're going to talk to the other midwife and, debrief what happened and try to see if you can reach some understanding about the standard of care. You should also know that if you were to make a report, the client would need to be interviewed. So sometimes in these situations, it's very important to also debrief with the client and see how they felt about the situation and discuss with them their options for going forward if they want to make a complaint. All right, so I think we can go on to the next slide, Kate.
Sure. So this slide has an awful lot of information on it. Let's talk about what midwives have to report about themselves. These are fairly black and white categories, but it's important as a regulated health professional that you're aware of the circumstances that do require a report. So you must report any change of name, contact information, or change in practice or hospital privileges to the college. You must provide information about any registration with another regulator in this province or in another jurisdiction, including if you become the subject of a complaint or investigation, if you are refused registration or license, if you are the subject of any proceeding, or if there is a finding made against you for professional misconduct, incompetence, or incapacity. The proceeding is a hearing process, and a finding is a potential outcome of a hearing process. You must report to the college if you become the subject of a coroner's inquest or verdict. You must let us know if there is a finding of professional negligence or malpractice made against you. It doesn't mean that you've been named in a lawsuit, but that it has gone through a civil court and a decision has been issued that finds negligence against you as a member. That being said, midwives must also file a report about a settlement or a judgment in a civil proceeding or lawsuit. Offenses and charges and/or bail conditions and findings of guilt of an offense must be reported to the college. Charges would be of a criminal offense, but offenses also includes, yes, speeding tickets or tickets for driving while impaired offenses. While a speeding ticket does require a report to the college, it's pretty unlikely that the college would need to take steps to address the conduct. Any bail conditions or restrictions that may have been imposed on a midwife are reportable to the college. Although this is an unusual report for this college to receive, the types of conditions for regulated health professionals charged sometimes include that individuals charged cannot contact the victim, there's restrictions on their ability to practice, the types of patients that they can be exposed to, or requirements that they be chaperoned in their practice. So you can see why it would be important for the college to be aware of this information and why this information may be posted to the public register. It allows employers and clients to make informed decisions on the care provider they choose. It alerts the college to situations where the registrar may need to conduct its own investigation. In the interest of time, we haven't focused on the timeframes for each report. You will want to note that a midwife should report information as it happens and not just at renewal time. The legislations require most reports to be done as soon as possible, or either 14 or 30 days, depending on the type of conduct. If you're unsure of the timeline, please check the college resources or give us a call. I think it's also important to note that while we recognize that everyone is human, you should make your best efforts to ensure that the timelines are adhered to, and the college does treat failure to report seriously. It is considered an act of professional misconduct to fail to comply with the legislation. But if you forget, just let us know as soon as possible. Make your report, including the details on the reasons for your delay in reporting. The legislation does set out fines that may be imposed for a failure to report, and in some cases, the registrar may decide to commence an investigation into a failure to report certain information to the college. Okay, let's move on to the reporting requirements of midwives who are owners or facility operators. The RHPA requires midwives who are employers to make a mandatory report for reasons of professional misconduct, incompetence, or incapacity. If they terminate, revoke, or suspend the employment of a midwife for those reasons, if they impose restrictions on the privilege of a midwife for those reasons, if they dissolve a partnership, a health profession corporation, or association with a midwife for those reasons. A suspension can be 1 day, 1 week. It still requires a report to the college. Examples of restrictions could be that a midwife must practice under direct supervision or is no longer able to practice in a certain area or cannot work alone. If any of these conditions exist and the midwife resigns to avoid the actions, employers must file a report. For example, if an employer states that they will be suspending the privileges of a midwife or provides an option for the midwife to resign before the suspension restriction is in effect, you still must make a report to the college. Another example could be if a person raises concerns with a midwife falsifying documents in their records and the midwife immediately resigns after the concerns are raised. It could constitute reasonable grounds for an employer to file a mandatory report. A termination or a restriction may protect the practices or facilities clients as they have addressed the risk at their particular practice. The rationale behind this reporting requirement in the RHPA, I think, is to ensure that the college is aware and can take appropriate actions if necessary to ensure the midwife doesn't move to another practice and repeat the same conduct there. Note that suspension or restriction is the threshold for reporting. The college doesn't need to be involved in the day-to-day operations of a practice or practice disputes that don't affect client care. The client regulates individual midwives, including midwives who are practice owners, but it doesn't regulate practices. Facility operators must report if they have reasonable grounds to believe that a midwife who practices at the facility is incompetent, incapacitated, or has sexually abused a patient. Sometimes the facility operator is the same as the owner. Note that this scenario does not involve imposing any restrictions when reporting competence or incapacity. The college recognizes that everyone's human and everyone makes a mistake from time to time, and not every mistake rises to the level that would be considered professional misconduct. We also recognize that mentoring, performance improvement, and support plans at the practice are put in place to ensure safe practice. The college expects that the employer will deal with some issues that come up and it will not trigger a report. However, when the concerns are serious enough to affect public safety to the extent that measures are taken to ensure safe practice, and the concerns relate to professional misconduct, incapacity, or incompetence, there is a requirement to report, and the college does want to know. I think the hard part sometimes is understanding what professional misconduct, incapacity, and incompetence are. It's a struggle for some, and frankly, sometimes it's a judgment call that must be made depending on the circumstances. The situation is not always 100% clear. In certain circumstances, midwives may wish to seek legal advice before reporting. It's also okay from the college's perspective to make a report and let the college assess the conduct. The next few slides. Oh, sorry, Deborah, I'm going to turn it over to you.
That's for me. So as Michelle said, you know, it is difficult sometimes to sort through all of the issues. And I would like to encourage you to, you know, always think about calling the AOM. If you do require a legal opinion or legal advice on something, we do have the ability to help you access that for most situations. So just to highlight that, you know, backing up before there's actually something that needs to be reported to the CMO, owners and partners have responsibilities for safety that go beyond the duty to report. So in the professional standards, there are some specifically geared at practice owners for providing an environment where there's quality improvement systems to support midwives' performance, and practice owners are also required to manage the practice in a way that supports the physical and mental well-being of midwives. So those things come into play, especially early in a situation before it gets out of hand, to think about whether or not those things are being provided. And then there are also, in any situation where there's a termination or a restriction of practice, as Michelle was mentioning, those as being part of the criteria for reporting, there's also consideration of contract law, your contracts with the midwife, workplace health and safety, and human rights legislation that need to be considered. So call us and we can chat through your scenario. I think you can go on to the next slide.
Okay, the next few slides will hopefully provide some clarity on the definitions of professional misconduct, incompetence, or incapacity. What is professional misconduct? It is a failure to do something required by the practice of the profession, or doing something that violates the legislation or standards of the practice governing the profession. To be professional misconduct, it must rise to the level that could potentially result in disciplinary action. The college's professional misconduct regulation lists all kinds of conduct that amounts to professional misconduct. The most common, like I said before, for this college is failing to maintain a standard of the practice. There are 47 acts of professional misconduct set out in our regulation, and it includes contravening a term, condition, or limitation imposed on the member's certificate of registration, to abusing a client verbally, physically, psychologically, or emotionally, or taking unfair advantage of a client as a result of the member's position in the midwife-client relationship. Conduct unbecoming and engaging in conduct relevant to the practice of the profession that would reasonably be regarded by members as disgraceful, dishonorable, or unprofessional, or other general acts of professional misconduct. So a simple example of what may or may not be professional misconduct is a midwife who was rude or yelled at a client. Does the rudeness rise to the level that it would be considered verbal abuse, or was it a simple miscommunication that the client thought the midwife was yelling? Let's move on to the next slide. Deborah, will you read that question?
Great. Okay, so question number 2, you have a midwife A who is a new registrant and practice owner C. And the practice owner notes that midwife A is having difficulty suturing perineal tears. The practice owner mentors the midwife A and develops a learning plan to address the concerns. Despite the support, midwife A continues to make errors affecting client care, and practice owner C decides that midwife A must practice suturing only under direct supervision. So should practice owner C make a report to the college about midwife A? So Kate, if we could have the poll. And people could just take a few seconds to answer, and then we'll have Michelle provide us with.
This is exciting. It's neck and neck.
I'm not surprised.
It's tough. It's very tough.
We're going to talk a little bit more about the gray areas in a few minutes. There are a lot of gray areas.
So we're at 80% participation, which is fantastic. I'm going to end the poll.
Wow. Okay. So it is really a judgment call. To me, this scenario demonstrates that there are reasonable grounds to suggest that there is professional misconduct and perhaps even incompetence in that the midwife failed to meet a professional standard and the care affected client safety. A report would be appropriate in this circumstance because a restriction was placed on the member's certificate of registration.
Yeah, and not to contradict the college's position at all in any way, because there is a point at which it becomes like, if it is supervision, it needs to be reported. And in this case, I emphasized, can't suture unless under direct supervision. So the gray areas are more around, should this midwife be given further training opportunities? And what is direct supervision versus just those things that we all do, even when you're a very experienced practitioner, asking another midwife, the second midwife at the birth, to have a look and, help with an assessment of a perineal tear, make a suggestion. There's a lot of gray area, but I think the point that under regulation, the CMO requires, there is a report required if it is actually supervision. All right, I think now I'm going to try, oh, sorry, Michelle, this is your slide.
Okay, thank you. What is incompetence? Incompetence refers to when a midwife's professional care of a client displays a lack of knowledge, skill, or judgment to a nature that demonstrates that the midwife is unfit to continue to practice, or that the midwife's practice should be restricted. So incompetence is a higher bar than professional misconduct. It talks about a pattern of behavior, an entire practice. It's not talking about one error. It speaks to a lack of skill or judgment, and that it is unsafe for the midwife to continue to practice. Deborah, I'm going to let you speak now.
Okay, great. Can you go to the next slide, Kate? Thank you. So, there are, as I mentioned, a lot of gray areas, and that's where I think sometimes calling the AOM and as necessary, we may help you to access some legal counsel around situations. Although, as Michelle said, you can make a report and the CMO will make a determination, but we're trying to think about questions that you can ask before deciding whether to make a report, so that you as practice owners or as another midwife reporting a midwife for professional misconduct, because you heard Michelle say earlier, the majority of reports around professional misconduct actually have to do with the standard of care, meeting the standard of care. I'm not wrong, right, Michelle? You can just nod.
You're right.
Okay. So here are some things you need to talk about. So it needs to be a pattern or something so big in terms of lack of knowledge, skill, or judgment that there is a significant threat to the public safety. To the extent that it demonstrates that the midwife is unfit to practice or their practice should be restricted. And it's a pretty high bar that's set for incompetence. A professional misconduct can be a lower bar because it can relate to a specific set of care competencies as opposed to a general incompetence. But, you saw that the CMO uses kind of a risk matrix looking at how serious the threat is. And, as midwives, we have to think in those terms as well. So, for example, you may have a midwife who makes endless mistakes in born data entry, always runs their clinic late, never restocks the clinic room, often interrupts practice meetings with personal business. Those are all things that may need to be addressed by the practice because they're disruptive and just not great. They cause conflict, but they're not things that need to be reported to the CMO. That does not create a picture of a professional professional misconduct that the CMO is interested in, because it does not constitute a threat to public safety. And the midwife's ability and willingness to recognize a problem and remediate a problem is really important. So if you're able to keep working on it and working together to fix the problem, especially at the earlier stages, that's great. If a midwife has a total gap in terms of recognizing the limits of their personal scope of practice or their competencies, does not acknowledge their learning needs, that obviously can become a situation where the practice group needs to take action and there may need to be a report to the CMO. It's interesting to talk about the standard of care, and the last question on the slide addresses that. So does the midwife in fact provide care in ways that would be acceptable in some practice groups, but is unacceptable in the current practice? So Kate, if you could give me the next slide, please. So when we're thinking about standards of practice, we have to remember that according to both CMO standards and legal standards, if you were involved in a legal case, the standard of care does not expect perfection. It expects reasonableness, and it does not expect that everyone within the profession will always manage the care in the same way. So in this little Venn diagram I made, you have the bigger blue circle, and that is the midwifery standard of care. What reasonably prudent midwives would agree is safe care in a particular situation, meets the standard of care. And then within that, we have my way, which of course I'm automatically probably thinking is best. And then there's your way, which is still within the midwifery standard of care, but is not meeting my norms and expectations. And we know there's quite a bit of variation across practice groups around certain aspects of practice. And if there's conflict about practice group norms, it's still a conflict and it needs to be addressed. And it may in fact result in the need for that midwife who's not adhering to practice group norms to leave the practice group, either voluntarily or by having contract terminated. But if they're not outside the midwifery standard of care, then it is actually not something that would need to be reported to the CMO. So this is a bad fit It is a bad fit between the midwife and the practice group. It ended badly. The midwife had to leave the practice, but it is not a contravention of the standard of care and doesn't need to be reported to the CMO. So when you have these situations, again, if you're looking for guidance after consulting with the CMO about the standards, you can still talk to the AOM about how to get through those things. That's it. Next slide, please. I just want to highlight a couple of controllable factors that negatively impact knowledge, skill, and judgment. And again, encourage practice owners and all midwives, in fact, to look at things that could be the root cause of performance problems they may be seeing. So inadequate change management is certainly one of them. We do get calls from practice or groups or individual midwives about a midwife struggling when there's a change. Either they're new to the practice and the practice group has a different scope than they're used to, midwives returning from leave, and new things being introduced. An example I'll use is an EMR, where one midwife is struggling to adapt to using the EMR, struggles so hard with that, they lose their situational awareness of other issues, and it starts to look like a more generalized incompetence because they did not have an adequate training and change management plan. And in some practice cultures, it doesn't really feel safe to ask for the extra support for a specific learning need, and that can encourage midwives to really struggle alone. And then there are situations of interpersonal conflict that result not from clinical care concerns, but just because we're human and we get into conflict. But it's well researched and well known that stress and conflict creates unsafe work environments. So that would be something for, the practice to look at if it's an underlying issue. And then last, but certainly by no means least, a competent midwife, excuse me, who is subjected to bullying, racism, or other forms of discrimination may be seen to be making more mistakes, may actually be making mistakes because of the stress or because of critical scrutiny, maybe having her judgment and actions questioned in a different way, and more often than would be questioned with other midwives in the practice. And of course, the practice group and all of us have a responsibility to fulfill the legal responsibilities for workplace health and safety and the rights that are protected under the Human Rights Code. Thank you. Next slide. You're muted, Michelle.
Thank you. Incapacity. So you can actually tell by this slide that this midwife really doesn't know if she should be making a mandatory report or not, because we know that sometimes it is a judgment call and she's really struggling with her decision making on this. Anyhow, incapacity refers to a midwife suffering from a physical or a mental condition or disorder that makes it desirable in the interest of the public that the midwife certificate of registration be subject to terms, conditions, or limitations, or that the midwife no longer be permitted to practice. Let's go into our sample poll question.
Sorry, now I'm muted. So question number 3, midwife B is feeling burnout due to COVID. She told the practice owner that she can't think clearly and feels overwhelmed. She hasn't made any clinical errors to date, but has requested time off to recalibrate. So in the midst of COVID, we all feel this pain, right? So practice owner A wonders if she should make a mandatory report about incapacity to the college. Should she?
Okay, poll is open. This one is looking a lot more decisive. Just going to give it about 5 or 6 more seconds. Excellent. Thanks, everyone. This is done.
Okay, great. So the majority of people said no. The definition of incapacitated is narrow, that it doesn't include all conditions and illnesses. And it does state only if it would make it desirable in the interest of the public that the member is no longer permitted to practice. In this scenario, the midwife has proactively requested time and she is not practicing. And so I think it would be appropriate that a report is not made to the college about this.
That's great. Thank you. Kate, can you give us the next slide? So I'm just going to, again, talk about a few questions that you may want to consider when you're thinking about whether a physical or mental condition warrants a report to the CMO. So we start with the reasonable grounds to believe, and this is not about reporting a midwife because they have a disability or a health condition. You need something rooted in fact, that there have been actions resulting from the condition that actually are causing risk. So for example, if you find out that someone attends Alcoholics Anonymous meetings, that is not a mandatory report. It becomes a mandatory report when you see something that may be related to them not controlling their drinking problem that impacts client care. And concerns should be based on current status. So you might find out that there's some previous medical history or previous performance problems, but we're looking at actions and behaviors that would currently be a threat to public safety as being the most important things to focus on, and definitely would be requiring a report to the CMO. And requests for leave or a change in caseload, call schedules, or other working conditions does not necessarily signal incapacity. We should firstly look at it as the midwife acting responsibly to ensure best performance for client safety. And we do know that the practice group does have a duty to accommodate under the Human Rights Code. It's a whole other webinar. And in fact, there is a whole other webinar. It's posted on the AOM member website. That talks about the duty to accommodate. And this is because it is a difficult area and a gray area. Don't hesitate to call at the AOM to chat about this concern. Thanks, Kate.
Okay, so where can midwives go for help about mandatory reporting? First of all, the college has a lot of resources on its website. We have a guide on mandatory reporting, a guideline for reporting sexual abuse. We have the actual legislation, the RHPA, the registration regulation, the professional misconduct regulation, college bylaws, and the college's standards of practice. College staff can help midwives and guide you in identifying which circumstances require you to make reports. We've discussed that there are a lot of gray areas. So depending on the facts of the case, and every situation is different, staff cannot provide you with legal advice on your legal obligation to report, but they can provide information about the college's resources and guide you in the right direction. Check back to our website often. We do have additional resources about mandatory reporting coming soon.
Great. And as Michelle said, the CMO can not necessarily provide you with legal advice. The AOM can provide you with legal advice. So definitely give us a call. And we're really aware that, you know, mandatory reporting is very important, but it's one aspect of safe care. And midwives across the province are working very hard to provide safe care every day. And yeah, just want to say that as a positive thing, and also to encourage you to call us if you do need support in any of these areas. That's it. We're a little behind times, but we still have a few minutes, I guess, for questions. Michelle, did you want to approach the questions first that were sent in advance?
I will leave it up to Ashley.
Yeah, I thought that
Okay,
might be best. I'll read out, I'll pose the questions that we have from previously, and then I also see that there are some in the Q&A chat, and if anybody else has any others, please feel free to put them in there while we're covering these ones. So the first question I'd like to pose is, what are the mandatory reporting requirements for inactive midwives?
A great question. They're actually the same reporting requirements for active midwives. When processing a report about an inactive midwife, the college will consider the midwife status as one of the factors when considering a report.
Okay, short and sweet. The next one is there mandatory reporting while on short-term disability? The example given is, I'll be off work for 9 months.
So there is no mandatory reporting requirement for midwives to report this information about themselves. Do note that midwives may consider transferring to the inactive class for this period. Depending on the circumstances and the nature of the disability, the facility, be it the hospital or the practice, may be required to submit a report. But if facilities are unsure of their reporting requirements, they may seek legal advice before making a report. There's not enough information for me to really comment further.
Sure. Okay, so the next question, the first question I see in the Q&A chat actually relates to question 2, the poll. So Kate, I wonder, could we go back to that poll and so everyone knows what we're talking about? And the question is, in the suturing example, what would the college do about it? So I guess, Michelle, could you speak to what would happen, what steps the college would take in that situation?
Sure. So like I explained at the beginning of the webinar, anytime the college receives information, we can conduct a preliminary inquiry. So the college would review the report and then it would conduct preliminary inquiries. It would look at how long I forget if we said it was a new registrant or not, but if not, if we didn't know how long the midwife had been practicing, we would look to see how long she has been practicing. Did she have a prior complaints history about similar concerns? We would also look about what the practice is doing to address the concern. And we would go through that sort of decision tree. Once we have all our information, we may seek information from the practice on how many clients were affected and what was the outcome of the mistakes made in suturing. And then once we have all that information, we would complete that decision tree sort of that I'm talking about to decide on an appropriate outcome, which could be an investigation or could be no action because the practice is supporting the midwife in her learning. So I can't answer what it would be, but that's sort of the process that we would go through.
Sure. Okay, the next one we have is if the MEP restrict a midwife's ability to precept has revoked the preceptor status, is this a mandatory report, and what would the college do?
So I can answer what the college would do. We would do that same process and look at the information. But to be quite frank, I'm not sure if that would be a mandatory report or not. It would depend on the reasons why the privileges were revoked of the preceptor. Did they relate to professional misconduct, incapacity? Was it in the course of practicing the profession? Or I'm not able to answer that question, but I can assure you that if we did receive a permissive report, we would look at the information and sort of go through that same process that I just explained.
Sure, and so that came in from an anonymous question, but if whoever that was, if you want to follow up for a more fulsome answer, please feel free to reach out and we can look into that more specifically. The next question I have is, how can the reporting midwife find out the results of a mandatory report about another midwife?
So they can't find out the results of an can you repeat that question?
Sure, yeah. How can the reporting midwife find out the results of a mandatory report of another midwife?
Yeah, so the answer is she will not be able to find out. She's reported information to the college and the college has acted on that information to determine if action has to be commenced to address the conduct. If the registrar decides not to take any action, the reporting midwife will not know. That information will be shared with the midwife who the report was made about. If the registrar decided to commence an investigation into the concern, and at the end of the process, the ICRC decided to make a decision that resulted in a public posting. So I'm talking here if the ICRC decided that the midwife had to complete remediation, attend the college for an oral caution, or there was a referral to discipline, there would be a posting made to the public register. And a reporting midwife could check the public register and see the outcome of the matter. No specifics are in the matter, but the reporting midwife may be able to tell from the content that's posted on the register that it relates to the conduct that she reported at. Let's say, though, that it did result in an investigation, and the ICRC decided just to provide advice and recommendations to help the midwife improve their practice. Again, the decision of the ICRC would be shared with the member who committed whose conduct was under investigation. And the reporting midwife is not made aware of that whatsoever. I would like to say that sometimes we do request information from reporters when we are conducting preliminary inquiries, but we would never confirm that we are, we would just get information from the reporter. And if there is an appointment of investigator, they may know that an investigation has commenced, but we do have that power to get information when we have appointments of investigator. But the outcomes are pretty private unless it's a public outcome.
Sure. Okay, the next question I have here is, if a mandatory report was filed and the concerning behavior continues, what are next steps? So I guess this would depend on the circumstances of what was reported.
Yeah, I mean, wouldn't it, Michelle, take, like, it would, if there is continued professional misconduct, then it's another report.
So like if we receive a mandatory report, if that's what I understand. So if, is it if a reporter has made a report and then the conduct continues and they want to make a secondary report?
Yeah.
Yeah. So again, the college would just consider that information. They would consider that it's the second time that they've received information about a similar concern, and they would go through the decision tree to decide on appropriate outcome. I think it would be treated more seriously the second time because the conduct is continuing.
Mm-hmm.
Can I just chime in too? I mean, if we're getting at so mandatory report is very specific around you terminated the midwife or the midwife resigned, trying to, evade charges of or questioning of conduct. They're not, it's eventually one would think that midwife would leave the practice group. I'm not sure a circumstance under which there would be a practice group where you had midwives where you were constantly making mandatory reports about them. You might be making permissive reports or and reports about professional misconduct, just to clarify.
Yes, I was under the assumption that the report would have been because the midwife is concerned about professional misconduct.
Mm-hmm. Okay,
moving on. I see two questions that I think are sufficiently linked. So can the midwife that's the subject of the report find out about who reported them, essentially? So another way it's phrased is it possible to make an anonymous report?
It's not possible to make an anonymous mandatory report. And the midwife who the report is received about will receive a copy of the mandatory report. So they will know who reported them. However, they should know that it is a mandatory report and that they are required to report the information to the college.
Can I just ask a follow-up though? Because I think, again, knowing midwives, including myself, we don't always understand the difference between a mandatory and permissive report. So any report, if I just decide that, you know, Ashley, my colleague, I need to make a report as a midwife about her professional conduct, does Ashley know that I've made a report about her?
And so when we speak to people that want to make permissive reports, we will let them know that we are sort of handicapped in our ability if they do not tell us who they are. So we may be aware of the conduct, but we may not be able to do anything about it, depending on what the conduct is, if the reporter is anonymous. And if the reporter is not anonymous and they agree to share their name with us, it is possible that their name will be shared with the midwife.
Okay, this leads into another question. What does the college do with reports submitted maliciously against another midwife?
That's a good question. I actually haven't seen any reports that I view as malicious. When we receive a report, we will assume that they are received in good faith. The college is aware that bullying, harassment, and racism are concerns of the membership. But I think that the process that we have in reviewing the material and going through the steps in our preliminary inquiries would uncover if there was anything malicious going on. However, if the college receives concerning information, it is obliged to look into the information affecting client care, even if the report was, well, the report has to be made about professional misconduct, incompetence, or incapacity. So they have to have grounds to make the report to the college. But I do think that the process that we have would flesh out any concerns of the midwife.
Okay, this is an easy one. Should the midwife report a speed ticket even if she's not on duty?
Yes,
Yeah.
she should.
I'm guessing there's a few midwives out there who didn't know this. I didn't know it before I got the education of doing this webinar. So
I think that the wisdom behind the RHPA in that regard is that midwives don't assess whether it's relevant to their suitability to practice, and so that we just receive all reports and then the college will decide which ones to act on. But yeah, I think you can be pretty confident that the college is not going to commence an investigation into one speeding ticket or more for that matter.
no, parking tickets though don't need to be reported.
No.
Okay, there's a follow-up question to one we've already been discussing. So following up on the need for a repeated report for ongoing poor trends, what if the midwife being reported is a partner?
So when the term poor trends is used, I'm wondering if it is a report about professional misconduct, incompetence, or incapacity. So the person that is making the report, regardless of whether it's a practice partner, would want to look at the circumstances, and if it has reasonable grounds to believe that the midwife who is a practice owner has committed acts of professional misconduct, incompetence, or incapacity, then they should be making a report to the college. It's hard to say without knowing the circumstances on whether they should or not, but if they believe that there's professional misconduct, then they should be making a report to the college.
Can I just weigh in too quickly, Ashley? So these are the kinds of situations too, because they also involve contract law, which is the partnership agreements, and they involve the power gradations within the practice group and dynamics and conflict and so on. Not to contradict Michelle's advice, I totally endorse it, but to say that, you know, this is a time when if you're struggling with that kind of situation, there may be the potential to need legal counsel around the other pieces of the responsibilities and how you deal with them. you can give us a call.
Okay. This question might be more on the legal side of things as well. It's, can partners add a clause in a contract with a contracted midwives, that the midwife must inform partners if a midwife is under investigation by the CMO?
So the answer to that one is, I think, yes, because almost anything can be put into a contract. The areas where we could get into some of those gray areas is, again, around disability justice, things that are protected under the Human Rights Code. But I think it is a reasonable thing that could be added to a contract. And again, consulting with a lawyer to make sure that the wording is appropriate.
Okay, and the final question I see here is, if the speeding tickets, is following on from the speeding ticket question, if it was 9 years ago, what are your reporting obligations then? So maybe we can talk a little bit about past, reporting on ongoing basis, or when you don't need to report older information.
So if you haven't reported it to the college, I probably would report it to the college. 9 years is a long time ago, but your reporting obligation still exists. So, I mean, you should report it to the college. But if you're just learning about it today, I understand maybe we're going to get a whole bunch of emails over the next couple of days. I'm not sure. But if you do, just know that we'll process the information that we receive.
Yeah, and I would just add to that you only need to tell us once. If your renewal, and you don't need to repeat the same information each year. Just make sure that the college knows everything that we should know, and once you've done it, you're covered, and you don't need to submit it ever again.
Thank you, Ashley.
So I don't see any others. If I've missed anything, feel free to jump in. But I don't see any other questions, and we are at coming up on 1:15, so maybe we should wrap things up. And if there's anybody has questions that we didn't get a chance to cover today, just send us an email. We're always happy to answer any questions that you may have.
Thank you.
Thanks, everybody.
Thank you all so much for joining us. Just a reminder that this webinar is being recorded, and we'll be sharing it publicly in the coming days.
Thanks, everyone.
Thank you.